Hello. So I thought I would take a break today from writing my appeal in order to make an instructional video on uh, how to commence an appeal. This is because I cannot find good videos about using the rules of civil procedure forms. Definitely UCounsel is a channel with great videos about appeals. And he promises to make a video about filling out the forms, and then he never delivers. And it's been about 5 years now, so UCounsel, if you're out there, go ahead and teach us how to make these forms. In the meantime, I'm just going to document what I have learned. And if there are other self-represented people who find themselves in appellate territory, then I hope you can work with me and we learn these forms together. These forms are not family law rules forms, they're much more sophisticated. Thankfully, there is a new notice of appeal form that is built out more like the forms we would be used to, in the sense that the general heading is streamlined for you. Probably because there was too many errors about action versus application. So yeah, rabbit hole alert. You always sort of need to know from the top down if you're dealing with an action or an application. And I cannot give you an overview. The statutes that I'm dealing with, such as the CLRA, contemplates applications. But a family law application resembles an action, if you ask me. I'm not a lawyer. Always remember that your specific situation, you need to get any legal advice that you think is pertinent. So what I'm getting at here is that working with these forms requires a fair bit of insider knowledge. They're not just plug and play forms like in family law rules. So without any further ado, we all understand commencement of an appeal is a notice of appeal served together with the certificate expecting evidence. Yeah, so what we'll do is use LibreOffice. Okay, I'm gonna go insert text from file, and here are my forms, and I'm gonna insert that, and then I'm going to go to the end of this form and I'm going to insert a manual break with a landscape page. Okay, and yeah, we're going to go to this page and whoops, get rid of all this formatting. Go to the end. A manual break with a landscape page. Okay, and here we're going to insert text from file 4C. Yeah. Next, the entire document, Times New Roman, 12th point. Okay. And then all of this, format, page. I want 4 centimeters on the left and double spaced like that. Okay. Next we're going to go back here, everything above this line, go back to single space. Alright. And everything below here, we'll go back to single space. Okay. Now, starting from the bottom, get rid of that formatting, get rid of this formatting. Okay. You versus me, and I'm the appellant, and you respondent. For file number, Court of Appeal, file number, and you want to leave that blank. Court of Appeal for Ontario. This should match the style up here. Court of Appeal for Ontario. Commenced at 6. Title of the document, Notice of Appeal. Now I notice a lot of people stylize this like this, which I think is pretty sick. So I stylized it also like that. Looks nice. Bold that. Italicize. It is not an affidavit. Oop. So we will just get rid of that. And I live at 742 Evergreen. Self-represented. 1, 2, 3, 6, 79. And Joe at c.ca. Email address, service. Here it's only asking for the email address, okay? Service to some fucking lawyer at ABC Law Firm. Yeah, got me. So that's good. That's your back sheet. That's how that works. Now we go back to the top here. File number doesn't exist right now. Give them some space. Get rid of all this. Yep. Leave that. Don't change it. Right here. I'm Joe C. No, I'm Millennial Nonsense. identify that I am the appellant. I was the moving party, and I am the appellant. And you are the respondent and the respondent in appeal. Yeah. The appellant is one person who is me, appeals to the Court of Appeal from the judgment of Justice unnamed let's see what that said. Name of the judge only. On the 99th of November 99th, 2062, from the Superior Court, Family Court, located at your city, Ontario. Following the hearing of, click here to indicate application, trials, application under the CLRA to determine the habitual residence of the party's child. There you go. I hope that helps. Next, we're going to ask the judgment be set aside and a judgment be granted as follows. Okay, here I'm just going to drop in a list, an order allowing the appeal, an order setting aside the court below, and an order substituting my preferred victory. I better not write that. An order, blah blah blah. Our costs in the court below. Costs of the appeal. Mercy. No, don't ask for mercy. Okay. So does this make sense? Now the grounds of the appeal are as follows. Here we put another numbered list. The court erred in pure fact by investigating its own court erred in by doing this. Does that make sense? If this fucks you around, just delete form control. Yeah. Okay, the court. So yeah, here you list about 5 or 6 grounds. Your grounds for appeal. The court erred in fact by finding the wrong fact. The court erred in mixed fact and law by applying the wrong test. The court is obviously wrong and fatal. Applying the wrong legal test. And the court erred in law by reciting the wrong statute for its decision. By a complete open forum where you can make up whatever you want. Those are your grounds of appeal. So as this is an originating document, it follows that this, in some respects, is your pleadings. In a way, it's a notice of a action, and well, perhaps it's a notice of an application, but regardless, this is an originating document. It has to contain all of your relief and all of your grounds, but it must also be brief. So it's, in that sense, it's like pleading. You get to just openly say what you want under the relief, and you just get to just openly say why. There's no evidence here, there's no argument here, you just, this is what's going on. This is your appeal in brief. This document is your appeal in brief. So moving along, the basis of the jurisdiction, this is kind of a nuisance, right? So we just get rid of all that. And here you must identify the statute that gives you the right to appeal. You don't just have a right to appeal, you need to find it in the statute. For example, so let's see what that all said again. Sorry. Let's see what the instructions said. Any statute establishing jurisdiction, final interlocutory, leave, and other facts. So again, in general, the statute is often section 1(6)(b) of the Courts of Justice Act, but not in family court. If your order is made under the CLRA, you check section 73 of the CLRA. If you are in the Court of Appeal, then your order is one of the exceptions identified, such as habitual residence. Additionally, section 2(2) of the Courts of Justice Act, of course you want to check, don't just believe me, check. Affirms jurisdiction of the Court of Appeal where it is conferred by an act. Okay, so together these two form the basis of the jurisdiction. You need to identify the order and judgment appealed from is final. I have absolutely no ability to discuss this on this video. The scope of a final versus interlocutory order is enormous. That is enormous in scope, and it requires a lot of research, a lot of reading, a lot of listening to podcasts. I just won't even. I won't even. You just need to know, and nobody can tell you. And leave is not required. Leave would not be required, for example, if this is a final order. So if there's anything else that's relevant, for example, I may want to explain that section 73 of the CLRA says appeals under the Act appeals orders made under the Act by the family court are sent to the divisional with in general, with the exceptions rated by subsection 2, including section orders made according to section 22 of the Act, which are without leave to dated this date of date, and I'm a self-represented jerk. I live here, and call me or write to fancy lawyer. I searched up your number, your Law Society number, your firm, your blah blah blah, your stylized silliness, and finally email. And then I'm going to write, you are the lawyer for the respondent. I don't know what that is, so I'll get rid of it. Yep. And it certainly appears to me that what we do now is make sure that all of the font is black. And that you can leave this stuff if it fills in nicely. Otherwise, I don't know. I think there's like embedded bookmarks in here. Yeah, so I wouldn't fuck with those. I'm not going to, but it looks to me like this. Yeah, we'll give her a one more once over to make sure it's all Times New Roman 12. Let's see, there we go. Grounds of appeal, standard of review is we'll go over the standard review very quickly. Your appeal can have basically three kinds of error. An error of mixed fact and law. You may also call it the court made an inextricable error of law in doing this to their facts. The idea is the Court of Appeal is not going to interfere with findings of fact. The idea is that for the Court of Appeal to interfere with the finding of fact, it basically has to be obviously wrong and fatal. So that's not the actual term of art. The term of art is a palpable overriding error. You can go for it. I know I'm going to go for it. For, you know, people, I'm sure they always go for it, but the Court of Appeal only overturns facts where there's a palpable and overriding error. Yeah, so you're looking for errors of law that are appealable, either extricable errors of law that come out of mixed fact and law, or errors of pure law. And you can talk to the chatbot about that, but the errors of law are reviewed on the standard of correctness, while errors of fact are reviewed on the standard of palpable and overriding error. And then you can also ask for the decision to be set aside if there's a reasonable apprehension of bias. But I wouldn't go that way. And yeah, I think that we are done. The last thing I'm going to do is highlight it all one more time to here and just justify, just to bring that all over. But we have our 4 centimeter margin. We got rid of all the headings, phone numbers. This is the proper style in accordance with 61B or whatever. You just make sure it reads cleanly. You don't change the prescribed wording. See, we get rid of that. And we get rid of that. Whoops. You know, stuff like that. Make sure you're asking for an order allowing the appeal. Make sure that your statutory jurisdiction is correct, rock solid. Make sure you know that you're dealing with a final order. If you don't have a final order, just forget it. Do not appeal an interlocutory order unless you need to. I may want to explain, I may want to state. You don't want to think you're explaining nothing, because there's a lot of writing involved. Don't overwrite. You're going to be doing a lot of writing. Don't forget your back sheet. And that's the end. Thank you very much. We have now, you can export that as a PDF right here, and then that is ready for service, along with the certificate respecting evidence, which will be the next video.